The Business Innovation Zone, also known as the BIZ, is the place to start for entrepreneurs in Iowa. The BIZ helps entrepreneurs and startup companies focus on idea development, business models, strategy, market validation, mentoring, and networking. We also help clients connect with qualified community and state resources needed to grow their business. Throughout the year, we provide a number of networking opportunities with experienced entrepreneurs and business leaders by offering monthly luncheons and all-day seminars on marketing and finance. You can learn more about the BIZ at bizci.org.
Thank you. So Mike asked me to come talk today about a couple of big things that are going on in the IP world. First of all, patent reform, which has passed and has starting to go into effect. And then also to talk a little bit about cyberpiracy and copyright law with the SOPA and PIPA blackouts that had happened in January, to give an update on what's going on with those and what's likely to come in the future. So I'm going to start with patent reform. It's called the Leahy-Smith America Invents Act. I'm going to give you a quick overview of what it means. It's the biggest change to our patent system that's occurred in over 100 years. President Obama signed it into law September 16th of 2011. 10 days later, all patent office fees increased by 15%. So that was the first big thing that happened as an effect of the patent reform. The rest of the major substantive provisions are going to go into effect within 12 to 18 months after the September 16th signing date. So the biggest change is a switch to the first to file system. The old system was the first to invent, and we were the only developed country using this system. So even if a patent application was filed before yours, you would have rights to the invention once you prove that you had invented it before the earlier filed patent applicant. So here's an example of the first to invent system. If you invented a product 2 years ago but didn't file a patent application at that time, and then today you file a patent application, then you find out that somebody else filed a patent application for the exact invention 5 months ago. Who gets the patent? Under the first to invent system, once you can show that you invented it first, you do. So now we're switching to this first to file system. So if you invented a product 2 years ago and file your patent application today, if someone else filed for the exact invention yesterday, who gets that patent? The first to file does. So even though you invented it first, you don't get that patent. This change, which is the biggest change, goes into effect March 16th of 2013. There's also changes within this first to file system with what's considered prior art. Now, prior art is what the patent examiner at the patent office is going to look at to decide whether or not your invention is new enough and different enough to give you the patent. It used to be, or under the first to invent system, if you could show that you invented it before a prior art reference, then the prior art reference wouldn't be considered by the examiner. So you could get rid of it. With the changes to the system, the scope of prior art is significantly broadened. It's based on activity occurring before your filing date instead of before your invention date. So in essence, if there's a publication or some kind of writing, something that was out there 1 day before you file your patent application, then that's going to count as prior art towards your invention, and the patent office is going to consider it when deciding whether or not you should get a patent. It also broadens it because it covers information that was in existence anywhere in the world, not just limited to the US. Under the old system, in certain circumstances, it was only US publications that the patent office was going to be looking at. There is kind of a little bit of a safe harbor in that an inventor's own publications that occur within a year before you file your patent application are not considered prior art. So you can publish a paper or have a poster at a conference or whatever, and still get a patent as long as you file for that patent within 1 year of that publication date. Now, that being said, if you do publish it before you file, you have foreclosed the opportunity to get patents anywhere else in the world, most likely. So you have to kind of keep that in mind when you're deciding whether or not you're going to publish. So why is this first-to-file system problematic for startup companies? Startups will typically have a lot fewer resources than bigger companies, and they often put off filing patent applications until they can get funding or have money. The first-to-file timeline typically doesn't work well for startups. Startups generally will start by talking to potential investors, customers, experts, co-founders. They just get out there and talk about their idea, work on building that business model, and they wait to file patent applications until they have money from investors, or they've further developed their product or invention. Inventors that we deal with already are kind of skittish about talking about their ideas generally with others because they're worried that someone else might get the idea and pursue it on their own. And this is going to make it worse for inventors because when they add in the concern about potential theft, so their prior invention date doesn't matter anymore, then they're going to be less likely to want to talk to people about it. Investors typically don't want to sign NDAs, which may also leave investors vulnerable, or inventors vulnerable. Investors a lot of times don't want to invest in a company until the company has a pending patent application. With this system, the first-to-file system, the risk is higher that another company will file first, rendering the target companies or the investors' investment worthless. The first-to-invent system gave investors some comfort that the invention could be covered by a patent, even if somebody else came and filed first, because they could get behind that filing date with the first invention date. Bigger companies obviously usually have more resources and can afford to file many patent applications. Startups usually have to pick and choose what they're going to pursue patent coverage for. And the requirement that they kind of pick and choose might cost the startups the race to the patent office. Another new provision under patent reform is post-grant review. In post-grant review, third parties can challenge the validity of another's patent, and this proceeding is going to take place in front of the patent office instead of a court. Currently, there's not a whole lot you can do. If there's a patent out there that you feel like is invalid and it's also blocking your ability to develop your own product, you can't do a whole lot about that patent other than get yourself sued for patent infringement. You have to be threatened with a lawsuit or actually a defendant in a lawsuit in order to try and do anything about the validity of that patent. The post-grant review proceedings are going to give you the ability to deal with those patents without having to go to court. The review proceedings are also going to give people the ability to provide the patent office with information about things that they think are relevant to pending patent applications. So if you know of a pending patent application that you think is invalid because maybe you invented it first and you have been out in the public with it for 10 years, then you have a better ability to show the patent office that prior use and hopefully get that patent stopped. Do these post-grant review proceedings benefit or hurt startup companies? It's kind of a double-edged sword. You can protect your inventions by clearing out others' patents that are blocking you, but you need the money to do it. These proceedings in front of the patent office are a lot quicker than federal court. We think they're going to be less expensive, but that still doesn't mean that they're not going to be a significant cost to a startup company. There's also some concern that patent trolls are going to surface in the Patent and Trademark Office proceedings, like they have in the court proceedings. And will competitors use the post-grant review proceedings to tie up or invalidate your patents, especially if your competitors are big companies with deep pockets? So back to patent trolls. Patent trolls is a term that's kind of thrown around in the media a lot. What patent trolls are typically are companies that buy up patents with no intention of using them. So they find patents that people have received but aren't doing anything with them, and then they'll buy them. They have no intention of developing a product, and they just use them to sue people for patent infringement. Typically, the lawsuits are filed against a large number of defendants. The patent troll plaintiff picks a favorable federal court, usually the Eastern District of Texas. I think the statistics are that about 88% of the time in the Eastern District of Texas, the case is going to come out in favor of the plaintiff in a patent case. So they gather up all these defendants, sue them in a favorable jurisdiction. The defendants are kind of stuck with each other, so they have to deal with having kind of a common defense or common timeline, even if it's not favorable to them. And it's hard for them to move their cases out of whatever jurisdiction the plaintiff filed it in. So the American Invents Act actually helps with this. This was effective the day that it was signed. Plaintiffs can't join unrelated defendants in a single suit, except in very limited circumstances. So you can't just say that because all 50 of these defendants are infringing the same patent, that's not a good enough common set of circumstances to put them all together in a lawsuit. So they're going to have to sue them individually in separate lawsuits. This will make it much more difficult to have, because you have multiple lawsuits going on in different jurisdictions at the same time. They have different timelines. And it's going to be a lot easier for defendants to move cases to a jurisdiction that's more favorable to them. So the thought is that the behavior of patent trolls is going to be curbed significantly with patent reform. Let's talk about fees again. Is there anything good to come of the increased fees at the Patent Office? Even though the Patent and Trademark Office is typically one of the federal government's biggest moneymakers, PTO fees have historically been diverted by Congress for other purposes. So they take money from the Patent Office and spend it on other things. Patent reform part of it was to end fee diversion, so the Patent Office gets to keep whatever money it brings in. The final law didn't actually fully abolish the diversion by Congress, but the PTO will have greater access to its fees collected. And the thought is that the PTO can use the increased fees and greater access to the money to hire more patent examiners to address the backlog of currently more than 1 million patents. Right now, the timeline for a patent application, if you file a patent application today, typically we're not going to hear anything from the Patent Office for 18 months to 2 years, and it's going to be 3 years to 5 years until you get a patent issued. So it's a very, very slow process. They're hoping that the ability to use the fees to hire more examiners, give better training to them, will cut down on that backlog and that time. One piece of good news for startups within the fee system is microentity status. Microentities are going to get a 75% reduction in most PTO fees. You qualify as a microentity if you meet all 4 of these requirements. First of all, you have to qualify as what's called a small entity, and that's a company that's less than 150 employees. You have to have not been named as an inventor on more than 4 previously filed patent applications. You can't have made more than 3 times the median income in the last year, which is currently about $150,000. And you can't have an obligation to assign your patent, to transfer ownership of your patent to a company that has a gross income of more than 3 times the gross household income in the last year, which again is the $150,000. I didn't put this on here, but all state universities actually qualify automatically as microentities, so they're all going to get a 75% reduction in fees, which is a really good thing. Some other provisions of America Invents. Business method patents, which that includes software patents. That's still patent eligible subject matter. So there was some thought that there might be some provisions in there that would curb business method patents. There are provisions in America Invents that completely eliminate tax preparation method patents, but general business method and software patents are still patent eligible. There's a prior commercial use defense. So if a party invents and uses an invention first but doesn't patent it, and then another party comes in and gets a patent for it, if you've used it first, then they can't sue you for patent infringement. So that's a good safe harbor defense. Most false patent marking cases are going to go away. Patent false marking cases, the example, I think the first example was Brooks Brothers. A patent lawyer discovered a Brooks Brother tie that had been marked with a patent number, and that patent had expired long ago. And the old patent statute granted monetary damages to a plaintiff who sued for false marking. So a patent lawyer started collecting products that had expired patents on them and started filing patent suits and making money on people not removing their expired patent numbers from their products. Most false patent marking cases are going to go away. If you have a product that has an expired patent number on it, there's no liability anymore at all. If you mark your product as patented and it's not, and you never had a patent, a competitor can sue you for monetary damages, but a patent attorney can't. So that's one change. I talked about how long it takes to get a patent out at the patent office. There's a new expedited process if you want to pay for it, so you can get your patent through the system quicker. The fee is $4,200 to get your patent expedited, and that's in addition to all the standard fees. There are relaxed requirements within the statute for companies to file patent applications on behalf of the company if the inventors are unavailable or what we call a hostile inventor. So the inventor's left the company, doesn't want to sign anything, doesn't want to participate in the patent application process. There's now relaxed requirements for what you have to do. Go ahead.
Quick question on that expedited examination. Now, under the new law, is that going to affect smaller businesses? Because it's going to be the first to file, not when it actually comes through.
So the expedited examination fee is actually, it doesn't really matter. Your filing date doesn't matter. Sorry, I'm going to repeat the question. He asked about the $4,200 expedited filing fee and if that makes a difference with the first to file system. That's just a fee to pay the patent office to make them look at your patent faster. So it doesn't matter, if you filed it first or second. It's just they'll crank it through the system faster if you pay them $4,200. I think that fee actually does qualify for the discount if you're a small entity or micro entity. So that's a good thing too. So back to the hostile inventors. If you've got somebody who was an inventor, your company's filed a patent application, you need your inventors to sign things or provide information to get the patent through the system. It used to be very difficult you had to go through show a lot of evidence that your inventor was hostile and unreachable and wouldn't sign anything for you. They've relaxed the requirements quite a bit, so you don't have to show them the hostility of your inventor. You can just do it on behalf of the company. So here's some startup strategies for dealing with the changes to patent law. If you have inventions now or coming up soon, file before March of 2013 for the benefits of the first to invent system. It actually also would probably be beneficial to file before then because it's going to be interesting to see how the system is implemented. I can't imagine that it's going to go particularly smoothly. So it might be better just to get the patent applications in quickly so that you don't have to deal with the mess that is going to be when this first file system goes into effect. If an invention is the core of your business, file a patent application sooner rather than later. File provisional applications as soon as possible to hold your filing date. Provisional applications are kind of a preliminary application. The filing fees at the PTO are not very big. I think it's maybe $100. Hold your filing date, buys you a year of time to improve your invention, decide whether you want to file a utility application, which is the full regular application. So consider filing provisional applications. There aren't many formal requirements for a provisional application either, so you can file a lot of PowerPoint presentations or white papers or things like that and call it a provisional application. So they're more informal. Try to use non-disclosure agreements when you're talking to potential investors, strategic partners, experts, anyone outside of your company. Try to use confidentiality and invention assignment agreements with your employees, your key employees and your founders. These are agreements that we're finding are really beneficial to companies. The confidentiality and invention assignment agreements make sure that all the intellectual property that comes into the company, whether it's with the founders or is developed by the employees, is owned by the company. And it dictates how a patent application is going to be handled. Pay attention to your competitors. Knowledge of what they're doing may help push you to file. I know a lot of companies are secretive, and it's good to be secretive about what you're doing, but try to pay attention to your competitors, and if you feel like that they're working in the same space as you are and maybe developing a similar product, get that patent application on file quickly. Take advantage of the new micro-entity status and find a patent lawyer used to drafting patent applications for startups. Take advantage of Iowa patent attorneys. Patent attorneys here are generally less expensive than they would be if you went to Chicago or Minneapolis. We cover just about every technical area that there is. So you can cut down on your costs if you take advantage of those lowered fees and then local attorneys. Get help with your employment agreements. This kind of probably doesn't seem like it's relevant to patent law, but your agreements need to be pretty specific about how patents are handled that are products of inventions that your employees or founders have made. Try to create a work environment where your employees are encouraged to quickly report inventions and have a defined process and timeline for them to disclose inventions to you. A lot of bigger companies just have an invention disclosure system where employees know that they need to document their invention process and notify key personnel of inventions immediately upon completion. And you can't file patent applications for inventions you don't know you have. So you just need to have a process where your employees are obligated to report to you what they're doing and working on so that you can make decisions as to whether patent applications should be filed. You need to learn to make quick decisions about whether or not to file, and it's a good idea to include your patent lawyer in those discussions. So I'm going to switch over to copyright now. Does anybody else have any questions about patent reform? Okay. Now I'm going to talk a little bit about copyright law and cyberpiracy. So Everybody probably heard about the SOPA and PIPA protests that happened in January. It was all over the news, Twitter, Facebook. I'm going to talk a little bit about what was going on with that and what I think is going to come. Cyberpiracy generally refers to online trafficking in copyright-protected works, typically movies and music. With SOPA and PIPA, the motion picture industry was the driving force behind those bills, mostly because of offshore companies that are distributing, sharing, providing access to copyright-protected movies. So what do we have in place now? Right now we've got legislation called the Digital Millennium Copyright Act, the DMCA. It's the existing law that protects copyrighted material, and it lays out procedures for enforcing online copyright laws. So under the DMCA, we'll use like YouTube for an example. If a copyright owner notices that YouTube has video on it that they think is protected by their copyrights, the copyright owner will send a takedown notice to the website that hosts the content, so YouTube. YouTube must immediately notify the user of their site who supplied the content, and then they take down, within a reasonable amount of time, the site has to remove the allegedly infringing content. The user who put the material there can file a counter motion to demonstrate non-infringement. But if YouTube or any other website follows those procedures, then they're protected by the safe harbor provisions of DMCA from copyright infringement. Critics of the DMCA argue that it's useless for overseas sites. So like these movie sites where you can obtain copyright protected movies typically exist overseas. So DMCA works well for companies that exist in the US, but not so well for ones that are offshore. So last December and into January, SOPA and PIPA were the big talk in the copyright community. SOPA and PIPA were generally kind of sponsored by the Motion Picture Association. And they potentially held the site owner, so YouTube, responsible for content that their users uploaded. So it put the burden on the website, the YouTube-like site, to actually police the content of the website. So these bills protected providers who proactively blocked sites that they considered to be infringers. The jurisdiction over these issues was with the US Justice Department. One problem with it is that problematic websites a lot of times don't host, deliver, or infringe copyrights, but instead only have links to infringing content. So these copyright provisions don't necessarily do much when the company that's distributing the illegal files doesn't actually have the files. They just host, or they just have links. It would have allowed the government to shut down the DNS address that directed a URL to the physical address of the server of its IP address. So essentially it would prevent a user from reaching, they call them rogue websites. But it wouldn't stop somebody who knew the IP address from just typing it in and getting there anyway. On January 18th, there was widespread protest. Wikipedia went black. That was one of the bigger ones. Protests all across the internet. And these bills actually have been tabled and are, for all intents and purposes, dead. So is the issue really dead? There's other forms of legislation that are in the works. There's OPEN, which is the Online Protection and Enforcement of Digital Trade Act. A representative from California has introduced this bill into the House. He did it in January prior to the SOPA-PIPA protest. kind of quietly. The entity the big difference with open is that the entity that's going to oversee this and decide whether there's infringement is the International Trade Commission instead of the U.S. Justice Department. The ITC already handles cases with foreign imports that are accused of copyright infringement. This is typically for goods, so if you've got a physical product and there's copyright infringement issues and the product is originating overseas, the ITC already handles those. So proponents of this bill think that this is a good change because the ITC has some expertise in handling copyright infringement already. The International Trade Commission would have to notify the website of the complaint, which was not part of SOPA. They didn't have to notify the website of the complaint. The representative from California is going about this in kind of an interesting and new way. The entire bill is available at this website, keepthewebopen.com, and it's open for public comment and revision suggestions. They've got a crowdsourcing program called Madison on the website, so you can provide comments and the program somehow decides to adopt some. The bill is actively changing based on public comment. Right now, as far as what's going to happen with it, it's just been introduced and it's got to go through the legislative process. So they still have it there for public comment and you can go check it out. Next thing is called ACTA, which is the Anti-Counterfeiting Trade Agreement, and it has recently been signed by 31 nations, including the US. This treaty will go into force after 6 of the 31 signing parties formally ratify it. It's very similar to the Digital Millennium Copyright Act, except it has an international scope. If you remember, the DMCA is criticized because it doesn't do much for overseas infringers. Existing laws are going to be unaffected by ACTA, so if it doesn't agree with an existing law like the DMCA is going to govern. If U.S. laws change, so if open were passed or something like that, after ACTA had been enacted, then ACTA would actually govern. So there's been some complaint about the ACTA treaty. First of all, that it was very secretive. The negotiations for the treaty were held very secret. WikiLeaks leaked the final wording of the bill. And also that if legislation actually does pass here, but ACTA is already in effect, then ACTA is going to just contradict everything that was just passed. So I don't know if anybody's heard about the mega upload issues. Mega upload was one of these offshore websites that had links to copyright infringing material, movies. The day after the PIPA-SOPA protest, the federal government actually shut down Mega Upload without even needing any legislation. Mega Upload made an outward showing of trying to comply with the Digital Millennium Copyright Act takedown notice system so that they would get that safe harbor. But the indictment, which was in Virginia, indicated that Mega Upload didn't remove all the links to infringing files. And it appears, too, that there was some internal communication within the company that made it clear that everybody at Mega Upload knew that that's what the website was being used for. So you can't fall under the safe harbor if you are just sort of pretending to go through the takedown notice procedure, but not actually doing anything about it. So existing laws, including the DMCA and international statutes, allowed the government to take down the website, even though there isn't SOPA or PIPA or something like that in effect. Mega Upload did have servers that were in Virginia, which gave the federal government jurisdiction under the Digital Millennium Copyright Act to take the website down. So I've been reading a lot about ways to deal with cyber piracy since this is all over the internet and you know, everyone's kind of up in arms about it. So are there other solutions other than legislation or treaties, international treaties? The music industry was actually the first industry that was hit really hard with the piracy with Napster. So the rights holders initially responded with copyright suits. And then it kind of switched to developing good products. And so Apple introduced iTunes and offered an affordable and convenient way of accessing music online, which resulted in sales instead of theft. Netflix has also responded to the market demand with its system of paying for content through subscriptions, and it shows that consumers are actually willing to pay for convenience. And this comedian produced a stand-up show that historically would have been released on DVD for around $20. He released it instead solely on the internet as a $5 download, and it took in $1 million in 12 days. So it just shows that instead of maybe going after legislation to deal with cyber piracy, innovators, companies, they can come up with novel ways, innovative ways to deal with it that actually divert the cyber piracy and drive up sales. So that's all I have. Is there any questions about any of that? Mike?
Emily, the provisional aspect of the Patent Act is very interesting. It seems to me like in 2013, you're trying to finalize a product and you 2 or 3 choices or whatever, and you might be forced to either make one selection or file 3 applications. But provisional lets you kind of file a general filing, and you've got a year then to kind of figure out which of those 3 ways.
Yep. And provisionals actually are still in effect. I mean, you can file a provisional now. We use them very frequently. So it's just a way to hurry up and get your application on file at the patent office. Typically now we use them a lot if a company has you know, a publication coming up. So they know that their article is going to publish in a journal in 3 days. And they want a patent application that hasn't been filed. They will have us do a provisional application which secures them that filing date, and then the publication occurs afterwards, so they're not concerned with any sort of public disclosure issues. But you know, when the system switches, I think the demand for provisional applications is going to go up even more, because it's just, you win the race if you get your provisional on file. And they're less expensive and they're more informal. So.
You mentioned at the beginning of the presentation that NDAs are typically signed by investors, and then of course the AIA mentioned that you really need to get them signed.
Yep.
Where do you see the real pushback, and is it mostly ego, or what do you?
Yeah, I mean, investors typically don't want to sign them just because they don't want to sign them. He's waving at me to re-ask the question. So the question was, investors typically don't want to sign NDAs, but we're recommending that you try and get NDAs signed as frequently and best you can. So where's the pushback? So yeah, investors, a lot of times they just don't want to sign them because they don't want to sign them. It's another thing that they just won't do. We're hoping that with the change to the system, the investors are going to, if they're going to have to start kind of changing their ways to be able to deal more effectively with inventors. So, you know, it depends on the investor. Some of them do, but a lot of them just won't talk to you.
What is the risk from their side that you would sue them? I mean, they sign something and then...
Yeah, I mean, you could certainly have a situation where you, is there risk on the investor side if they do sign an NDA? There's certainly some risk that you tell them about your invention, and you have something else in the works that's similar, and you're bound by this non-disclosure agreement, and you can't move forward with your other thing. I suppose that's a risk, although most non-disclosure agreements tend to try and carve out exceptions like that. But yeah, I mean, I think that they think it kind of binds them to and lowers their ability to do other things.
If you're a startup and as you say, you're not focused on this at all, what are your two biggest takeaways from this presentation in terms of what's the biggest change you've got to be aware of, and what's the most important strategy for you to implement?
So what's the biggest change to be aware of, and what's the strategy to implement? The biggest change to be aware of as far as patent law goes is to the first to file system, the change to the first to file system. You need to be aware of that. And the response, the thing you need to do probably the most is file patent applications quickly. So you got to make a decision that that's going to be your strategy and you need to act on it. Other questions?
Any other questions? All right, well, thank you very much. If I could, real quick, I can tell you where the investors are coming from because I've been in those shoes. For a serious venture capitalist who's looking at 20 to 30 deals a week, they can't tell you what the invention was. They heard about it at 10 o'clock this morning, 4 o'clock in the afternoon. They don't remember. The other thing that happens, and it used to happen to me all the time in my last company, is people would bring you this invention and say, here's my unique, incredible invention. No one else knows about this. I filed a patent. And you know that 9 other people have brought it up. You know that you already have prior art. You know that. So as an investor or an owner of a company, you do get in a situation where just filing a patent doesn't mean you're going to have the patent. And just because you think it's new and different doesn't mean it's new and different. So there is that. I think that the key thing is let your investor know that you have something that's patentable or patented. And if they won't sign the NDA, just tell them what it means. Don't tell them how you did it. Don't give them anything non-disclosure, or don't give them anything unique. Just tell them what the outcome is. What's the business value of this? And if they want to dig in more, if they are interested in your deal, then they will sign your NDA. The problem is on a first meeting, again, if you're doing 40, 50 first meetings a week, you're not going to sign 40 or 50 NDAs because you cannot do your legal requirement of making sure you haven't discussed this information. You just can't keep track of it all. So I would say that there is a little bit of defensible position, but it's not something you can't get around as an entrepreneur. There is an evaluation sheet on your table. We love feedback. Anything you can tell us about how to make our events.